Welcome to another episode of Real Estate Pulse with MacQueen and Gottlieb. I'm really happy to be here with Patrick MacQueen and Ben Gottlieb from MacQueen and Gottlieb. So guys, I have to tell you a story. So we're currently looking for a house right now. Found the perfect house, but they insisted that it be sold as is. It's a historic house built in 1925. So I had a little bit of apprehension. I had a buddy of mine who's a contractor come and take a look at it. Turns out there was no HVAC system in the house at all. So is that happening a lot in the real estate market right now, where people are just selling houses as is, and then the buyer is stuck with whatever they're stuck with?
Yeah, yes. Short answer is yes. So the standard form real estate contract that the Arizona Association of Realtors has provided and produced, and most agents and most transactions are utilizing, actually has an as-is addendum in it, or an as-is clause in it. The as-is clause basically means, hey, we're selling this to you as is without any warranties. We're not going to tell you whether this stuff is good. We're not going to fix it if we don't have to, unless we agree that we're going to fix it. So it's very common. An as-is addendum or an as-is provision is common in almost every single real estate transaction now. When it gets highlighted, though, when people are waving their hands around, hey, I'm selling you this property as is, hey, I'm not going to give you the seller property disclosure statement, which is another common document, that puts up a little bit of a red flag. It says, oh, maybe there is something wrong with the property. Why are they highlighting this so much? Because again, the contract already is as is under Arizona law. And so in your situation, maybe they were highlighting, hey, this is as is because we know something doesn't work. They may not have disclosed it to you right away, but it's very common for an as is to be a part of a contract these days.
So how about when they ask you to waive the inspection, Ben?
Yeah, so a couple of years ago that would be very unlikely or unheard of. But what happened over the pandemic is the real estate market here in Arizona and elsewhere evolved, and the dynamic became very seller biased or seller favored. And so it's very, as everybody knows, it's very common, as you probably know, it's very common these days where you might have 4 or 5 buyers bidding on a property within a week. And so now it becomes this competition, and what can the buyer do to win the sale? They can waive the appraisal contingency, they can waive the finance contingency, they can waive or shorten the inspection process. Doing the latter, waiving the inspection process, is really not a recommended strategy for the seller, because ultimately that's going to hurt the seller. And the reason is, if you do get embroiled in non-disclosure litigation, where the buyer comes and sues later and says, hey, seller, you did not disclose a material fact to me and I've been damaged, and so now I'm suing you. If you end up in that situation, oftentimes in court, what the seller will do is they'll say, well, wait a minute, you had an inspection, you had a full opportunity to inspect the property, you had an inspector come, memorialize his or her findings into a lengthy inspection report, and they notified you as the prospective buyer of all the potential issues with the property. And so you knew or should have known about the issue that you're complaining about. So it's actually a fact that's used to protect the seller in non-disclosure litigation. And unwittingly, today sellers are thinking that's an advantage to have the buyer waive that process. But Arizona law is still Arizona law, even if it's a seller dynamic market. So seller favored dynamic market. So it's an interesting fact, but ultimately I think the inspection process is something the seller should still want the buyer to go through, because it's for the benefit of all the parties, not just the buyer, but also the seller.
Okay, so you just spoke about the law. What are the laws regarding misrepresentation in residential real estate?
So you have to disclose anything that may be material to the transaction. That's the law in Arizona. So sellers have an obligation to do that, and selling agents also have an obligation to disclose things that may affect the transaction as well. So to me, in this market, you should disclose everything, but we're just not seeing that. We're not seeing the extent of disclosures as we thought we should, as we thought we would. We're seeing more bad fix and flips. We're seeing more non-disclosure cases than ever before. And I think that's largely a couple of reasons. The reason being is that buyers are waiving their inspections. But I also think, which we don't recommend, like Ben said, but I also think that now sellers are getting there's a lot more competition to flip these homes, to buy a house and whether they're wholesaling it or they're doing a fix and flip, and it's much more competitive, and so they're cutting corners. And so we're starting to see that. We've seen that for a couple of years now, where there's cutting corners, there's buyers waiving the inspections, and so those cases go on the rise when that happens.
How much of an increase in the number of misrepresentation cases are you seeing compared with, say, 5 years ago?
Well, I can tell you this, over the last 5 or 6 years, I personally have handled between 225 and 230 misrepresentation cases. Whether it's on behalf of the seller, whether it's on behalf of the buyer, whether it's on behalf of an agent. Oftentimes agents are named in there because there's the impression that the agent knows something about it too, or assisted the seller in the non-disclosure. So I don't know how much of an increase that represents, but it's pretty significant over the last 5 or 6 years.
That's crazy.
It is.
So we're talking mostly about residential here, but does this impact the commercial side as well?
It does, and we handle commercial misrepresentation cases. Recently, we had a very big one. It involved a commercial income producing property, and there was a big issue with the rent ledgers and the tenant estoppel certificates, and ultimately the buyer wanted to sue the seller because the buyer said, wait a minute, you misrepresented the nature of these tenants, and therefore you misrepresented the expected income flow, and I overpaid because you signed what were called seller estoppel certificates. So you, as the seller, actually signed some of these estoppel certificates affirming that these tenants were in good standing, were well-paying tenants, were not in default of their lease, and those facts were false. Those representations were false. And so ultimately, I've been damaged from that. The other interesting aspect of this area of the law, and this applies both in residential and commercial, and Patrick touched on this, a lot of commercial sales involve as-is clauses, as well as residential sales, but most commercial transactions involve a situation where the buyer, who's presumably a sophisticated commercial buyer, is taking the property as is, performing their own inspections, waiving warranties. But there's a key case in Arizona that came down about 20 years ago by the Court of Appeals, and what that case said was, listen, even though in the commercial context or residential you're taking the property as is, the seller still has disclosure obligations. Okay, and this is probably one of the bigger misconceptions in seller non-disclosure law. A lot of these sellers think, well, I'm getting the buyer to sign an as-is clause, so I don't have to worry about anything, and that's not true. So you can still sue as the buyer for fraud, even if you did take the property as is. And Arizona law makes clear those claims will go through if you have the evidence to prove your case.
Wow. So what are some of the elements that are contributing to this rise in the number of misrepresentation cases that you're handling?
Well, that's an interesting question. I would say that there is more competition, so I think that's one of the elements to this. People see Arizona as having a bustling economy, and you can make good money in real estate here. And so we have people here who want to do that, and there's a lot of competition for that. We also see situations when rains happen. So whenever it rains outside, we see all of these issues really come to the forefront. So for whatever reason, the rains kind of bring out a lot of these misrepresentation issues.
Is that right?
I literally had a case where there was an exterior wall and an interior wall, and there were weeds growing between the two. This was a brand new interior wall, and the flipper must have seen, or the seller must have seen that maybe the weeds were a little bit smaller, but then the rains come in, that it gets more moist, and by the time the case had come out, we cracked open the wall and the trees, or the weeds were this high. So I think it's the rains. I think it's the interest in Arizona. I think we have a lot of fixers and a lot of flippers here and a lot of kind of some people who are doing it the right way, some people who aren't doing it the right way, and so it just creates this big combination. But usually we'll see them after it rains, a little while after it rains, because that kind of pushes some of the issues, the roofing issues, the drainage and flow issues. That's when we'll see them. So it's it hasn't rained yet, but it will at the end of the summer, and that's when they'll come.
There's all these popular home flipping shows on TV. It makes it seem like it's so easy to make a bunch of money, but has that led to a number of problems in this area, misrepresentation?
It has. I mean, and fix and flips, that's been around obviously before the pandemic, but what we've seen since the pandemic arose are a lot more cases, in addition to what Patrick said, that are caused by rainfall and the consequences of that, but also basically just from people purchasing properties sight unseen. And we have overseas international clients that purchase, from Europe. They purchased a house in Scottsdale, never even visited the U.S. before making the purchase. So that's some of our cases. And so you just didn't have that before to this extent. I know you have a lot of virtual tours right now, and I'm not sure if that's really a full substitute for an in-person inspection of the property. So, I would absolutely say that at least a certain reasonable percentage of the current case flow results from people just not even visiting the property prior to purchasing it.
And that seems like it never happened 5 years ago. It seems like this whole industry has just changed so much. So Patrick, what are some steps that people can take to make sure that they don't find themselves in a misrepresentation case from the buyer side?
Certainly, from the buyer side, get an inspection. I mean, get 2 inspections. If it's a fix and flip, get 2 inspections. Ask who the contractors were. Look up the contractors. There's an easy way to look up the contractors. You go to the Arizona Registrar of Contractors website to see if that contractor is licensed and to see if they've had any prior trouble. You can look up cases against these sellers, because there's a group of sellers out there that get sued all the time. These fix and flippers. There's some folks that we've seen many times. And so
you're on first name basis.
Yeah, we are unfortunately on a first name basis with some of these guys. And so if you can kind of dig into the documents that you're receiving, get those extra inspections. It's not gonna mess up the sale. The seller, like Ben was saying, it benefits the seller if a buyer gets an inspection. So get 2 in some of these instances. If you're buying a historic home, like you said, have somebody out there, an architect, an engineer saying these walls are good, these pipes are still good. Here's what needs to happen if you want to fix X, Y, and Z. But people just aren't doing the same level of due diligence that they were previously, and that's what's really biting a lot of people. So again, getting multiple inspections. Whenever your inspection report reveals something, hey, you should have a pool specialist look at X, Y, and Z. Have a pool specialist look at X, Y, and Z. Mm-hmm. Take that advice. But far too many people are just jumping in, buying. They want to get in. I get it, but that you may be inviting a headache down the road.
How about from the seller side? I know they don't want to end up in court either, or end up on the bad end of a case. So what can sellers do to make sure that they don't find themselves in court?
Well, sellers, if you're doing a fix and flip, put it in an LLC. That may give you some level of protection of your own personal assets. But to me, it's disclose. Disclose everything. Disclose if you change the light bulb. Some people inherit a property from their grandma, and maybe it's true that they haven't been in the house for 13 years. But when they were, there 13 years ago, did they change the light bulb? Did they help grandma paint this? Whatever it is, disclose everything. Because in this market, buyers are still going to buy. And so the more you can disclose, the better you're going to be in case an issue does come up. So if you're a seller, if you're doing this as a business, consider getting an LLC, certainly. Making sure you're dealing with a reputable trade folks and folks who are licensed, and then disclose everything. I mean, again, in this market, you can disclose a lot, and people are still going to buy.
Okay, last word, Ben, on misrepresentation. What do people need to watch out for?
Yeah, it's a great question, Michael. I mean, I think for one, this is maybe a little bit more economic, but for one, how are interest rates in the current environment going to impact the real estate market? That's yet to be seen, but that could influence the dynamic and maybe make it a little bit more neutral or less seller biased than what we've seen, and that might impact some of these misrepresentation cases because maybe you won't have so many buyers bidding for property and then ultimately waiving in the inspection process and things that we've talked about today. So that's one thing to look for. And then the other thing is, are we going to still see a lot of these buyers purchasing properties sight unseen? Because that, in line with waiving the inspection process, is going to continue to lead to a lot of non-disclosure cases. So.
Okay, everybody loved it in our first episode. I asked you at the end, give me one trend to watch in real estate law in the next year to 5 years. Patrick, what should people be watching for?
One. I'm gonna say homestead. The new homestead laws. but there was a bill that was recently signed, as you brought up to me this morning, about the wholesaling industry. I haven't dug too much into that, but there are a lot of frustrated folks who allowed a wholesaler to purchase their home for less than probably what it was worth, and so I think there's some interesting dynamics to come on that.
I'd love to talk about the homestead law the next episode. So, okay, Ben, what turn to watch?
I think it's in line with our first episode, but I think it's going to be HOA law. So based on the Callaway case, the Arizona Supreme Court case that came down a month ago, it's going to be really interesting to see how lower courts handle challenges to not only future proposed HOA amendments, but also previously passed amendments. So I think what you're going to have are homeowners come in and say, our CC&Rs were amended 2 years ago or 3 years ago, and under this new Arizona Supreme Court opinion, this is an invalid amendment. And court, we want you to strike these various amendments. It's going to be really interesting to see how lower courts handle that and how they interpret Callaway. Obviously, the more narrow they construe Callaway, the more challenges we're going to see. It could really dramatically change HOA law here in Arizona over the next 1 to 5 years.
Okay, great. Okay, Patrick, if people need your help, how do they get in touch with you?
602-533-2840, that's our main line, or patrick@mnglawgroup.com.
Okay, Ben?
Yeah, same number, 602-533-2840, and ben@mnglawgroup.com.
Okay, or go to their website, mnglawgroup.com. Thank you for joining us for Real Estate Pulse with MacQueen and Gottlieb. We'll see you next time.